Welcome to this explainer. Okay, so human sexuality, morality, and the law, these three things are basically on a massive collision course. It's a fascinating, deeply misunderstood area of human behavior. Virtually no one is indifferent when it comes to the sexual marketplace, and today, we're putting aside the cultural taboos and the emotional reactions. We're going to look directly at the sexual marketplace and unpack exactly what the data, the law, and the research actually tell us.
Now, you might think our moral outrage and legal debates around sex work are, a relatively modern invention, but when archaeologists uncover a 2,000-year-old Roman bathhouse fresco in Salonika, it provides some pretty glaring physical proof that while our legal frameworks change, the profession itself has been around for literally millennia.
To navigate this whole complex web without getting completely lost, we've broken this explainer down into 6 key areas: the oldest profession, choice, coercion, and vulnerability, the clients and the law, defining pornography and obscenity, erotica versus pornography, and finally, the effects of pornography.
All right, let's jump right into Section 1, the oldest profession.
Before we really get into the weeds here, we absolutely need to nail down our working definition. Society throws around an endless list of subjective and, let's be honest, pretty derogatory slang for this trade. But for our purposes today, we're defining sex work strictly as providing or receiving sexual acts by specific agreement between a sex worker, the client, and sometimes an employer in exchange for money or some other form of remuneration.
The thing to remember is that this industry is definitely not a monolith. It's like night and day, depending on the setting. On one hand, you have street-based sex workers who typically make the least money, face shockingly high risks of arrest and violence, and struggle with high rates of illegal drug addiction. Contrast that stark reality with highly regulated, state-controlled brothels, like the ones in Nevada. In those legal environments, workers are dictating their own schedules, sharing fees with management, receiving regular medical care, and consistently using condoms. It's a completely different, significantly safer world.
So that brings us to Section 2, choice, coercion, and vulnerability.
Now, there's always this huge debate, right? Do people in poverty turn to sex work and then start using drugs, or does the drug use come first? Well, empirical data lays out a pretty tragic timeline. On average, first drug use happens at just 15 and a half years old. Regular and even intravenous drug use follows soon after. And it's actually not until age 20 and a half that the first experiences in sex work typically happen. So addiction is deeply, deeply intertwined with the trade. It acts as both a gateway in and a mechanism keeping people completely trapped.
While some highly paid call girls or legal brothel workers genuinely choose this path for financial freedom, we have to recognize they just don't represent the vast majority. Most street-based workers are pushed by massive systemic drivers. We're talking extreme poverty and really early sexual initiation, usually a year to 2.5 years earlier than non-sex workers. Add to that tragically high rates of childhood abuse, severe coercion by partners or international trafficking networks, and intense drug dependence. Estimates show up to 95% of street workers are addicted to crack cocaine. When you stack all those factors up, the whole concept of choice becomes incredibly complicated.
Moving on to Section 3, the clients and the law.
It's time we bust some common myths about the quote-unquote typical client. When you look at the demographic breakdown, the truth is clients are often completely integrated, everyday members of society. 58% are white, 42% are actually married, and half are primarily seeking oral sex. And here's an interesting caveat. Research tells us that only 18% of married men who purchase sex claim dissatisfaction with their sex lives at home. Instead, many are literally just buying a brief, completely transactional encounter that's entirely free of emotional or relationship baggage.
To put all this into perspective, here is a truly staggering statistic. 81% of these clients are working full-time. They are middle to upper class, educated individuals. For the longest time, law enforcement fiercely targeted the sex workers themselves, an approach that, honestly, has proven universally ineffective. But now the focus is slowly shifting to the reality that this massive demand is being driven directly by everyday, fully employed members of society.
So, how do we handle this legally? Well, the debate basically boils down to 2 entirely different approaches: legalization versus decriminalization. Legalization means the state steps in and heavily regulates the industry, dictating where, when, and exactly how it takes place, kind of like those Nevada brothels, specifically to protect public health. Decriminalization, on the other hand, just wipes the slate clean. It removes all criminal laws relating to sex work, treating it like any other standard business transaction, to destigmatize the workers and take the burden off the legal system. Both sides argue passionately about which method actually does a better job of protecting vulnerable populations from violence and trafficking.
All right, shifting gears to the visual side of things. Section 4, defining pornography and obscenity.
Now, you might be wondering, why try to define obscenity at all? Well, it's not just some abstract philosophical exercise. In strict legal terms, pornography is any sexually explicit work that's officially deemed obscene. And that definition is absolutely crucial, because it dictates exactly what is protected by our First Amendment right to free speech, and what could literally land a distributor behind bars.
To tackle this massive legal headache, the Supreme Court came up with a three-part moral standard test. A work is considered obscene if, first, it's patently offensive under state law; second, if the work as a whole lacks serious literary, artistic, political, or scientific value; and third, if an average person applying their own contemporary community standards finds that it appeals to prurient interests. Basically, this means local communities get to decide for themselves what's obscene. Unsurprisingly, legal scholars have heavily criticized this ruling, arguing that it's just way too vague and completely subjective.
Which brings us right to Section 5, erotica versus pornography.
Culturally, we draw a huge, somewhat blurry line between these two concepts. Think about it. We tend to view erotica neutrally, or even positively, as a mutual expression of physical desire and passion between people who are freely choosing to engage with one another. We even appreciate it as art. Pornography, on the flip side, is much more often viewed pejoratively, as a mere tool designed solely for immediate, isolated sexual consumption.
Back in 1980, Gloria Steinem made a really powerful assertion about this exact split. She argued that the fundamental divide isn't actually about how explicit the imagery is at all. It's entirely about power dynamics. Erotica is about sexual sharing and positive choice. But pornography, which literally comes from root words meaning prostitution or female captives, is fundamentally about sexual using, domination, and power. It's a completely different framework.
Finally, let's look at Section 6, the effects of pornography.
You know it's a complicated issue when even presidential commissions, with all their vast resources, can't agree. Take the 1970 Johnson Commission. They looked at the data and found no clear evidence linking pornography to discrimination, and basically just recommended better education. But fast forward just 16 years, and the 1986 Reagan Commission concluded the exact opposite, that pornography was definitively dangerous and directly increased violence against women. Though I should definitely mention that many social scientists heavily criticize that 86 report as being unscientific and distorted by bias.
So what happens when we look past the politics and focus purely on the clinical data? Well, we find an incredibly nuanced picture. For example, men might report higher arousal from degrading content, but their actual enjoyment and acceptance of that content drops significantly. As for women, they report much higher arousal when viewing content that is specifically made for women by women. When it comes to relationships, one partner viewing secretly often causes massive distress, but shared viewing can actually yield positive effects for the couple. And regarding the leap to real-world aggression and violence, the correlational studies remain incredibly mixed. It just proves that human reactions to this stuff vary wildly from person to person. As we wrap up this explainer today, I want to leave you with a final thought to chew on. We've traced the ancient roots of the industry, we've looked at the vulnerable populations trapped by poverty and addiction, we've unpacked the everyday demographics of the clients, and we've waded through the tangled legal web of defining obscenity. So, at this incredibly complex crossroads, here is the big question. Does attempting to legally define and regulate the sexual marketplace actually protect the most vulnerable among us? Or does it inevitably infringe upon personal freedom and individual expression? It's a heavy debate, and for sure it's one that is far from being settled.